Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis. This dictation is for the aspirants who are preparing for Delhi High Court PA exam. Get ready for the dictation without any stop. Without adjudicating the petitioner's petition on merits, we are of the considered view that interest of justice would be best met if the petition is disposed of in the following terms. Since the vehicle in question stands seized in relation to the FIR which stood registered long ago, in case confiscation proceeding has not been initiated, it must be initiated within a period of 15 days from today, and that confiscation proceeding stands initiated, we direct the appropriate authority under the Act to forthwith ensure that such proceedings be concluded not later than 30 days. The petitioner undertakes to make himself available in the office of the concerned appropriate authority empowered under Section 58 of the Act, that is District Collector, in his/her office on 4/2/2020 at 10:30 am. We further direct the appropriate authority to positively conclude the confiscation proceeding within next 30 days on appearance of the petitioner. If for whatever reason such proceeding cannot be concluded, in that event it shall be open for the authority to take such measures as are permissible in law for release of the vehicle in question by way of interim measure on such terms as may be deemed appropriate considering the attending facts and circumstances of the case. If eventually the appropriate authority arrives at a conclusion that the property is not liable to be confiscated, it shall be open for the petitioner to seek damages in accordance with law and have appropriate proceedings initiated against the erring officials. Learned counsel for the petitioner states that the certified copy of the order shall be made available to the concerned district collector on the date so fixed. For future guidance where parties have not approached this court, we issue the following direction. The expression reasonable delay used in Section 58 of Chapter 6 of the Act, in our considered view, necessarily has to be within a reasonable time and with dispatch, which period, in our considered view, 3 months' time is sufficient enough for any authority to adjudicate any issue, more so when we are dealing with confiscatory proceedings. We clarify that we have not adjudicated the writ petition on merits, and it shall be open for the parties to take a stand in the adjudicatory proceedings, and wherever parties are aggrieved, it shall be open to them to initiate appropriate proceeding before the appellate authority. Learned counsel for the state also undertakes to communicate the order of the concerned appropriate authority, that is district magistrate empowered under Section 58 of the Act. It is seen that despite our observations, the appropriate authorities have not taken any action in initiating the proceedings for confiscation of the property under the Act. The litigants are thus forced to approach this court by way of filing separate petitions. Thus, today we are left with two options: either to initiate proceedings for contempt under the provisions of Contempt of Courts Act